But before I set in motion the submission of the party expressing its view on this disturbing matter, let me refer to the 2015-2016 1 Supreme Court of Ghana Law Report, specifically at page 175, in the matter of Martin Pegu number 2 versus the Attorney General number 2, in writ number J1/13/2025. This reported case was delivered on 5th May 2016. I shall rely on the general view of the courts in their declaration. Quote, Article 19C of the 1992 Constitution has given a suspect under investigation or an accused on trial the benefit that he was innocent until the court had found him guilty after a hearing or following a plea of guilty. The grant of bail was one of the tools available to the court to ensure that a suspect or an accused, as the case might be, was guaranteed his innocence until the court had found him guilty. The presumption of innocence in terms of Article 19(2)(c) of the Constitution embodied freedom from arbitrary detention and also served as a safeguard against punishment before conviction. It also served as a preventive measure against the state from successfully employing its vast resources to cause greater damage to a person who has not been convicted than he could inflict on the community. Therefore, any legislation outside the Constitution, such as Section 96(7) of Act 30 as amended, that took away or purported to take away, either expressly or by necessary implication, the right of an accused to be considered for bail, would have prejudged, presumed him guilty, even before the court had said so. That would be clearly contrary to the letter and spirit of Article 19(2)(c), which has guaranteed his innocence until otherwise declared by a court of competent jurisdiction. End quote. And specifically, my Lord Doche JS, who was part of the majority at page 176 of the law report, said in these veritable words, which I quote, Article 19(2)(c) of the Constitution takes precedence in the laws of Ghana, and any law found to be inconsistent to this constitutional provision must, on the basis of Article 21A and 131B of the Constitution of 1992, give way and be declared inconsistent and in contravention of the Constitution 1992. In my opinion, Section 96(7) of Act 30 as amended is one such legislation that is inconsistent with the Constitution. The general tenor of Section 96 of Act 30, which deals with grant of bail in general, therefore gives very clear indications. On the whole, the courts have a discretion to grant bail to persons appearing before them in criminal cases upon conditions stated therein. The ousting of grant of bail in Section 96(7) is therefore odd and unnecessary interference with the discretion of the courts. The lead judgment of the court delivered by my brother Benin JSC, striking down 96(7) of Act 30 as amended as unconstitutional, in which I concur, is not a carte blanche for the court to admit every Tom, Dick, and Harry to bail pending trial, because the removal of the statutory shackles in the impugned Section 96(7) of Criminal Code Offences Act 1960, Act 30. On the strength of this, I set in motion the concerns of the party in respect of the remand. It has been designed to achieve one aim: to allow a person who is injured to resort to civil reliefs. But what Ghanaian law does not provide, and what it was never designed to provide, is the conversion of a civil grievance, assuming without admitting that one even exists in this case, into a criminal prosecution. It does not authorize the marching of a man before a circuit court, the stripping of his liberty, and his consignment to state intelligence facility. That is not justice. That is the iron fist of state power wearing a legal glove. On the 13th of May 2026, Mr. Abronya was arraigned before here in Accra. He faces 2 counts. First, offensive conduct conducive to breach of the peace under Section 2071 of the Criminal Offences Act 1960. Second, publication of false news under Section 2081 of the same statute. And what is the foundation of these charges? A social media video in which Mr. Abronya criticized a circuit court judge. He questioned that judge's impartiality. He questioned the conduct in the discharge of the public duty as provided for in the judge's judicial function. That is the sum total of his alleged crime. He spoke. He criticized a public officer. By the way, since when did criticizing a judge become a criminal offense in Ghana? Section 2071 requires conduct that is likely to occasion a breach of the peace. Political criticism of a public official, however sharp, does not meet that threshold. It is protected expression under Article 21(1)(a) of the 1992 Constitution. And the false news charge? A man expressing a political opinion about judicial conduct is not publishing false news, not by any honest reading of that provision. This prosecution of Abronya is built on sand, and we, the party, will watch it fall. The bail denial. A judge who forgot his oath. By the way, that was not his first. Let me turn to what happened in that courtroom. It demands its own separate and pointed rebuke. Counsel for Mr. Abronya presented a bail application. He argued on solid grounds. The charges, as we all know, are misdemeanors. The accused, as it was made known to the court, has a fixed place of abode. He is a known public figure with reliable sureties. His health and family responsibilities were placed before the court. The prosecution opposed bail on one ground only: that Mr. Abronya, if released, was likely to commit similar offenses. I repeat, according to the has not administered justice. I say what I'm about to say as a practicing lawyer, as someone who has spent his professional life in courtrooms, who has profound respect for our judiciary and deep admiration for those who carry the weight of dispensing justice. I say this not in anger, but in fidelity to the Constitution I have sworn to uphold, and with all the candor, humility, and respect I can command. When a court denies bail not to serve justice, but to serve silence, it has administered political censorship from the bench, and that, with the greatest respect, is a betrayal of every principle that gives judicial office its authority, its dignity, and its legitimacy. Now, let me specifically deal with the nature of the remand. It was a BNI remand, and indeed, even so, there is a missing court order. No court order drawn. Every remaining doubt about the political character of this prosecution is removed by the decision to remand Mr. Abronya into BNI custody. The BNI, by law, is Ghana State Intelligence and Security Service. It is not a remand prison. It exists to address genuine threat to national security. Mr. Abronya posted a critical video about a judge. That is not a national security matter. It never was. This has nothing to do with the criminal justice and everything to do with political intimidation. But there is something even more alarming. I want every Ghanaian to hear this clearly. Even those who hate the guts of Abronya must at least listen to this matter. It has now been 4 days since the court pronounced the remand order. 4 days, as I understand it, on the basis of information available to the party at the time of this statement. Counsel moved up and down the courtroom, the registry, demanding for certified remand order. The court order, as at Friday, has still not been drawn. I therefore simply ask a simple question. On what legal basis did the Ghana Police Service take Abronya into custody and conveyed him to the BNI? On what legal basis did BNI accept and held him? A remand order is not a verbal instruction. It is a formal judicial instrument. It is a written legal authority upon which the deprivation of a citizen's liberty must rest. Was a Ghanaian citizen delivered into intelligence custody or nothing more than a word of mouth? If so, that detention has no documented lawful foundation whatsoever. So I ask again, the Director General of BNI, did you receive any court order accompanying Abronya's detention? If so, can you provide a copy? If not, why did you accept it? And I ask my Lord, if my Lord thinks he's bold enough, both demand accountability. Now we see the ghost of criminal libel coming back, buried by Kufuor, but resurrected by President Mahama. There's a deeper dimension to what this government is doing, and it must be named plainly. On 27 July 2001, Ghana's parliament unanimously passed the Criminal Code Act 2001 Act 602, which repealed the criminal libel and seditious laws. President John Ajekun Kufuor gave his assent on 2nd August 2001, striking from our statute books one of the most notorious instruments of state censorship this country had ever known. That repeal was a defining moment in Ghana's democratic maturation, a declaration that in free society, the state has no business imprisoning citizens for what they say. The bill was presented to Parliament by Nana Addo Dankwa Akufo-Addo, the Attorney General as he then was. The world applauded. Ghana was held up as a model for Africa. But before we go further, let me be precise about one important historical fact. The criminal libel law was not created by the PNDC or NDC. It is a colonial inheritance, drafted in 1893 by the British colonial administrators and expressed dissent against imperial rule. Dr. Kwame Nkrumah, our first president, inherited it at independence. It was codified in our Criminal Offences Act 1960. The law predated the Rawlings era by decades. But what history will never forgive the PNDC and NDC for is this: they weaponized that colonial relic most ferociously, most systematically, and with the greatest cruelty against the citizens of a free Ghana. Under PNDC military regime of Jerry Rawlings, journalists, academics, lawyers, trade unionists, and ordinary citizens were arrested, detained without trial, and tortured for daring to speak. The culture of silence was not a metaphor. It was a lived reality enforced by brute state for power. Mr. Tommy Thompson, publisher of Free Press, and Mr. Michael J., a senior writer, in 1982, were among those imprisoned without trial for editorials critical of the PNDC. Mr. John Kublenu, the editor, was separately arrested in 1983 and detained without charge before being transferred to Nsawam prison. He died in 1984. Shortly after his release, his health destroyed by the conditions of his detention. He was never charged. He was never tried. He simply died for daring to write. Tommy Thompson himself continued to face harassment and repeated prosecution and died in 1998. His death, a direct consequence of brutalities he endured in his long fight for press freedom. 2 men, 2 deaths. The blood is on the hands of that regime. Abdul Malik Kwekubaku Jr. was arrested and tortured under the PNDC. He has spoken publicly about being made to crawl the full length of Military Parade Square on his knees until they bled, about being caned on his waist, about 25 days at the Force Engineers facility that left him physically impacted, about losing control of his bodily function for days on end, all for speaking truth to power. Kwesi Pratt Jr. was jailed and tortured during that same period. So was Akotampa and many others whose names history has not fully preserved. Then came the NDC in constitutional form. And even under the democratic dispensation, the party found uses for the criminal libel law it had inherited. On 23rd July 1998, 2 of Ghana's most respected newspaper editors, the same Abdul Malik Kwekubaku Jr. of The Guide and Alhaji Haruna Atta of Weekend Statement, were convicted by the Court of Appeal and sentenced to 1 month in prison. Their crime? Publishing a story about the former First Lady. They were dispatched to separate prisons, Akuse, Winneba, and Anmabo, in a deliberate attempt to break their spirit and prevent visits from supporters. Images of Kwekubaku and Haruna Atta in handcuffs being marched to prison are etched in the collective memory of every Ghanaian who loves freedom. In 1996, editors Nana Kofi Kumsi of the Ghanaian Chronicle, Ebenezer Kwaku, and Tommy Thompson of the Free Press were arrested and charged with publishing false news with intent to injure the reputation of the state. Those exact words, publishing false news, the same statutory weapon this government is now deploying against Abronya. And when the court came to repeal the criminal libel law, the then NDC chairman, Obed Yawasamwa, who had also served as Attorney General under Rawlings government, declared publicly that the law could be repealed over his dead body. Over his dead body. That is the NDC's historic relationship with free speech. That is the tradition President Mahama now chooses to continue. The NPP abolished the law that the NDC swore to keep. And now the NDC is quietly rebuilding what the NPP tore down. Now the Mahama administration, unable to openly reverse that landmark reform without international condemnation, has chosen a more cunning path. Rather than restore criminal libel by name, it is reconstructing the criminal libel regime in practice, hiding behind sections 207 and 208 of Act 29 to achieve through the back door what it cannot defend through the front. The charges against Abronya, Baba Amando, David Esando, and others are in substance and in effect criminal libel prosecutions. The only difference is the label on the charge sheet. The intent is the same. The mechanism is the same. The consequence is the same. Arrests, remand, imprison, silence. For a Facebook post about electricity outages afflicting millions of Ghanaians. Then Mr. Abubakar Yakubu, NPP Sunyani East Communications Officer, popularly known as Baba Amando, arraigned before an Accra Circuit Court, remanded, charged with offensive conduct, false publication and circulation of statements likely to incite fear and panic. The same judge, Court Circuit Court 9, the Agenda Court, the NDC Court. And let me repeat it, that NDC judge, he must be ashamed of himself. Mr. Alfred Abebi-Okumi, known as Adente Kumi, was arrested by operatives of the National Investigation Bureau in a dramatic dawn raid on his home. His wife suffered a miscarriage as a direct consequence of that raid. His crime? Submitting a petition to the president concerning the conduct of committee members sitting on the Chief Justice removal proceedings and making comments in media interviews and on social media about the same matter. He was formally charged with publication of false news under the same statutory provision being used against Abronya today. And there's a case of Reverend Intim Fojo, a member of parliament for Asin South and a ranking member of Defense and Interior Committee of Parliament. This is a sitting member of parliament, a duly elected representative of the people. Again, BNI operatives attempted a raid on his residence after he raised concerns about 2 aircraft that visited Ghana and alleged possible links to drug dealings and money laundering. It took his colleagues in the minority caucus to physically resist attempted arrests. Dr. Baumia, our flag bearer, himself had to visit him to reassure him that a member of parliament should require reassurance that he remains free after raising matters of national security concern in the discharge of his public duty is a statement of the most alarming kind about where this country is headed. And now Abronya, remanded into BNI custody for criticizing a judge. There are no isolated incidents. They are selected examples from a deeply troubling and growing list. That judge has no respect for his own judicial oath. I don't think he read the law. That Circuit Court 9 judge, I have no respect for him. For a judge to say that he's remanding Abronya into BNI custody until the case is finally determined, such a judge can never have my respect. I pray that he summons me for contempt. I will continue to disrespect him until he upholds the law. He's gone